Let's get started because we have a limited amount of time. My name is Roy Kaufman. I am the Managing Director of both Business Development and Government Relations at Copyright Clearance Center. Today's event is part of our ongoing AI Copyright and Licensing LinkedIn Live series. If you're returning and have heard some of our other events, welcome back. And if you're new, we've got some really great programming coming up. Some of my colleagues are working on as we speak. So please sign up, follow what we're doing. I, as the moderator, had a chance to look at who was joining this meeting from your side, just to give you a sense of who else is listening into this talk. We've got people from many of CCC's corporate clients. We've got some of the best known technology firms listening in, trying to figure out what we're going to say. We've got publishers, we have academics, and we have government officials. There's a really broad group of people who have come to hear this, which doesn't surprise me. I'm not here to tell you how important AI is. We all know that. My career has spanned the birth of the popular internet and digital publishing, and I've never experienced anything where the change of pace in both markets and the regulatory environment is as fast and furious. And a lot of us are just trying to navigate. We're working in multinational situations, we're working globally. How do we navigate all of these different concepts and all of the known unknowns and the ambiguities? So what we're hoping will come out with today is understanding of, in part, how EU standards in the past have sometimes been adopted as more global standards. We're going to discuss whether we think that's going to happen in the AI environment. This is a CCC event. We will talk about, not so much, but touch on licensing and how we believe licensing can help in some of these matters. Hopefully you'll leave this with a couple tools, a couple ways of approaching and thinking about these issues as you go back to work. Couple things, we are going to be taking questions. We want questions from the floor. However, I'm not going to ask them until a little bit later in the program. Ask questions whenever you want. We probably won't get to everyone's question. I'm apologizing in advance. We will group questions, obviously, to try to get to the best themes. Before I hand it over, last comment, you can't have two lawyers on an event without a disclaimer. So on behalf of Professor Bradford and on behalf of Roy, what we say is personal, our personal views. We're here in our individual capacities. Nothing Professor Bradford says should be attributed to Columbia Law School or Columbia University. Nothing I say should be attributed to CCC. We want to have a frank and open conversation. So with that disclaimer, I have to just tell everyone how excited I was when I wrote to Professor Bradford and she said she would do this event for us. She is the author of The Brussels Effect, and if you haven't read her books or any of her papers or seen her on YouTube, please do. It's amazing. She is the Henry L. Moses Professor of Law and International Organizations at my alma mater, Columbia Law School. I could go on forever, but I don't want to because I want to hear Professor Bradford speak, and then I'll come back and we'll have some discussion and then hopefully get to some of your questions. So with that, over to you, Professor.
Thank you so much, Roy, and good afternoon, good morning, everyone. It's truly a delight, my pleasure to be part of this conversation with you today. And I hope that I can share some insights on why all of us, even if we are not based in the EU, should care about how the European Union regulates the digital economy, including artificial intelligence. So this takes us to this concept that I have labeled the Brussels effect. So let me first set the stage by introducing the term the Brussels effect and tell a little bit about how that has shaped the global digital environment and what might happen now in the era of AI and AI regulation. So the term Brussels effect refers to the European Union's unilateral ability to regulate the global marketplace. The EU is one of the largest and wealthiest consumer markets in the world, and there are very few global companies that can afford not to trade in the EU. So as the price for accessing the European market, these companies who want to do business in Europe, of course, need to comply with European laws and regulations. That's not surprising. Where it gets interesting is that often these global companies choose to follow the European regulation also outside of the EU. So they are conforming their global conduct or their global production to the EU regulations. So this is why we see companies like Microsoft or Apple or Google follow the EU's GDPR, the General Data Protection Regulation, excuse me, also in the United States. So you might wonder, why would a powerful American tech giant voluntarily choose to extend a European regulation even to the markets that don't require the same privacy standard? And the idea here is that since they need to anyway conform to the EU rule, they have already adjusted their business practices to that rule. It is often easier for them. There are benefits of scale economies, benefits on more streamlined legal compliance, to then use that same rule also in their home market, the United States, or in third markets, whether they are in Japan, whether they are in Latin America, whether they are in Africa, because they want to avoid the cost of complying with a different regulatory regime in every market in which they operate. So simply by conforming to the highest standard, which often happens to be the European Union standard, these companies get the benefit of a uniform single code of conduct and a global market access. So this is how the European Union has become often a global regulator simply by regulating the single market. So you may wonder, why the EU? So of course, you need to be large enough of a consumer market for you to be able to set the global standards. If you are, let's say, Costa Rica, and you want to have the world's most stringent AI regulation or privacy regulation, and the companies don't like your regulation, they can simply choose not to do business in your market, and rather than be active in the rest of the world. But the EU is just too big for these companies to conclude that, okay, we don't like their regulations, so we are not going to offer our services and products in the EU. So this explains why the regulations like the GDPR have become globally so influential. Another way the EU has increased its global influence, that the European regulations have often become templates for foreign governments to follow. So today we have over 150 countries that have a variation of the GDPR as their own domestic privacy policy. So now let's talk a little bit about whether we believe the Brussels effect will also take place in the AI space. So we are probably not surprised. The EU has developed its reputation for its propensity to adopt high standards, be very vigilant in regulating the digital economy, whether we talk about content moderation or privacy or antitrust. So when the AI era arrived, the Europeans were the first to move. So the Europeans adopted the world's first binding, comprehensive horizontal AI regulation that entered into force in August 2024, and that is now in the implementation stage. So before I address the question whether we expect this regulation to also have a global influence, let me take maybe 2 minutes just to explain the basic framework of the AI Act, so that everybody now today being part of this conversation is on the same page. So the AI Act is a risk-based regulation, which means the riskier your AI system is or your AI model is, the greater the compliance obligations are. So there is a 4 categories or tiers of risk, if you like. There are those AI systems that propose minimal risk, or then those that propose limited risks, or high risk, or unacceptable risk. The focus is on the 2 top categories. So unacceptable risk, which basically denotes the category of AI systems. Let's say, for instance, real-time facial recognition surveillance, so mass surveillance of individuals. Those are altogether prohibited in the EU. The second category is very important because it reaches across so many businesses, the high-risk AI. So if, for instance, a bank uses an AI system to screen your eligibility for credit, that is considered a high-risk setting because your rights as an individual seeking credit are directly and fundamentally affected. So there are various obligations that is not prohibited use of AI, but you need to follow these heightened obligations in terms of, for instance, you using an unbiased data sets, you keeping the logs of the development of your models, and there are various kind of risk mitigation obligations. So then when the EU was at the final stages of adopting this risk-based regulatory framework, the ChatGPT was released. And the big question was, what is going to be done with generative AI? And the European regulators decided to add a general purpose AI models, that's the terminology in the legislation, within the scope of the AI Act. And as a result, all the GPAIs, the general purpose AI models, are subject to rather extensive transparency requirements. So they need to disclose how their models are being trained, including what data is used to train these models, including then copyrighted data. Then the more powerful general purpose AI models, like you would have now, the models many of us are using, the large language models, they are subject to additional risk assessment, risk mitigation, cybersecurity, other requirements, because they are considered potentially posing a systemic risk. So all these provisions are hard law. They are real obligations that the companies need to follow because they are also subject to real sanctions. Up to 7% of the global turnover of the companies, and in the case of these general purpose models, up to 3% of the global turnover. These are enforced by the national level regulators in the EU, but also supervised by an EU level AI office. And for instance, the EU level AI office is in charge of enforcing the AI Act with respect to these big foundation models. Okay, so that's the basic framework for regulating AI in the EU. Now the question is whether we believe that this will have an extraterritorial effect or shape the way AI is being now developed also outside of the EU. So as the first observation, I think it's important that we understand that the AI Act applies even if you train your models outside of the EU, but then you offer those models for use in the EU market. So the non-EU providers are also subject to the EU's AI Act. There's also an expectation, and it's still somewhat hard for us to evaluate because the implementation is now in stages being introduced, and we don't quite yet know exactly how the implementation will unfold in the coming years. But for instance, we have now already observed that several leading tech companies, AI developers, have signed the EU's Code of Practice. This is an accompanying to the actual AI Act that specifies many of the rules, including the copyright provisions. And all the major AI providers, with Meta excluded, have signed on to this code. That means they are indicating their intention to comply with the AI provisions and are communicating the way that they intend to then implement these provisions in practice. There are also many benefits of then potentially using the EU's legal framework outside of the EU. Unless you want to develop different models, train the models separately for different markets. There are certain benefits of scale if you decide that you anyway need to inform the EU users of what kind of data you have trained your AI models with. that information is available also for the users outside of the EU who also know, for instance, if their personal data, their copyrighted data, other data has been used for the training purposes. So in that sense, it is hard to confine the effect of the EU's AI Act only within the jurisdiction of the EU. Once the company has in place the documentation, the risk management system, the incident reporting, everything that the EU requires them to do, there are many companies that likely conclude that they will be then unrolling just the same practices outside of the EU. Of course, it is possible that some of these companies say that, look, this is expensive. This limits how we can provide these models. If it is cost effective, we might be choosing to create a different version for a different market that allows you then to forgo some of the requirements in the EU that we find to be too burdensome. However, the fact that companies are expected to comply with the EU regulations in the EU also changes the conversation and expectation in different parts of the world. So you have greater demand by the users of AI to make sure that the protections that the European users of AI are enjoying under the EU's AI Act will be also available for them. Other regulators around the world are paying attention to what the EU is doing. They may be then following up with the legislation of their own. We already see some countries, a notable one, for instance, South Korea, came up with a rather elaborate, the EU-inspired AI Act of its own. It does not copy word by word what the EU's AI Act does, but South Korea, like several others, are now considering the kind of tiered risk-based approach to regulation. They also have a readily available template on how to regulate general purpose AI. That is something that might also get copied in other jurisdictions. Here in the United States, it's very interesting. California, that has often been more eager to regulate technology than some of the other states, has already implemented, I would say, at least an aspect of the EU's AI Act with rather extensive transparency regulations that then resemble many aspects of the EU regulation. So you need to disclose under California rules, like the EU AI Act requires you to disclose, if you are, for instance, interacting with a chatbot companion, so that you know that you don't have a human on the other side of the conversation. The same thing with the disclosure of the training data. That is also a California provision that rather closely tracks the transparency disclosure requirements of the training data for the generative AI that are available in the EU. So those examples, Roy, suggest that we have other regulators paying close attention to what the EU is doing. The fact that we have many companies that have already signed on to the EU's Code of Practice and are already adjusting their conduct to the EU's AI Act. I think we at least need to pay very close attention what is happening to the EU AI Act and expect, even if not complete, that partially at least the Brussels effect will be extending the reach of that law also outside of the European Union.
Wonderful, thank you. There's so many things I want to follow up on. So let me begin just with a comment. It's not just South Korea and California, and nor were you implying that. I've seen a lot of draft federal legislation in the United States where, again, it's not the AI Act, but a lot of the concepts, particularly around disclosure of training data and other things, have come up. We've organizationally supported some of those efforts. I live in New York City, and New York City has its own rule for very high stakes. If you're using AI in employment, you need to disclose it. You need there are all kinds of requirements. I'm not entirely clear many employers are following them, but at least there are laws on the book. So we have been seeing, I think, the EU, whether you agree with, as a matter of policy, what they're doing, they do tend to be very thoughtful and complete in their drafting in a way. The AI Act, you didn't mention much about copyright, and that doesn't surprise me because I think the AI Act, they kept saying wasn't about copyright. I always refer to it as copyright adjacent. There are things in it that are copyright related, but not really. The EU was pretty clear. No, we already did copyright, and maybe we'll do it again. But right now, we've done it in our digital single market. We're not reopening that. What are your thoughts generally on sort of how copyright concepts work within the AI Act, and then possibly again within the Brussels effect more broadly?
Yeah, so Roy, it is a good question because the AI Act itself is rather brief when it comes to copyright, but it certainly communicates that there's a greater awareness that copyright infringements may take place if you are training your AI models with copyright protected material. So the AI Act recognizes that the developers need to respect copyright. And that obviously is not a very carefully delineated provision. What does compliance mean in practice? A lot of work for lawyers. But the EU already expected that at the time the AI Act was released, that there will be more elaboration, including then in this codes of conduct. But the AI Act itself requires not only that the model developers are respecting copyright, but they are transparent about the data that they are using to train their models, including text, including images, in music, and so forth. So this way, the AI Act also interacts with the copyright directive, because the copyright directive, as I think many individuals in this call know, allows for an exception from the copyright protection to text and data mining. And there's an understanding that the training of these AI models fits within this exception. So basically, you would not have the copyright protection. But importantly, in accordance with this copyright material that now needs to be a copyright directive that needs to be respected by the EU's AI Act, right holders can opt out of that exception. So the right holders can reserve their rights, and that means that if they have done so, if they have opted out of the training, the AI model developers need to respect that opt-out. So that is a clearly very, very important part of the AI Act and directly affects how copyright works. So given that this was a rather brief way to just make the reference to the importance of following the copyright, there was an AI code of practice. So I mentioned already in my initial remarks that this code of practice is designed to be, even though it's voluntary, to give more of a texture on how the compliance can be assured in practice. And the companies that choose to sign on to this code can then get the benefit of lighter regulatory scrutiny, because if they follow the code, they are assumed to be in compliance with the EU's AI Act. So that also then elaborates of how it goes, how the model developers need to go about then informing the rights holders of the data that they have used for training. So they need to publish a sufficiently detailed summary of the data so that the rights holders can then actually exercise their rights. But what is, I think, also important is the AI Office, the centralized EU enforcement body for the EU's AI Act, has provided a template for this disclosure. So we want to make sure it's easy, it's streamlined, and that template might also potentially have the Brussels effect, because now we have a certain format that these companies, when they are disclosing information about their training, they are likely to follow, because they need to assemble that information for the EU anyway. They need to make that available for the public, for the regulators, including then obviously for the right holders, but that then can become the template, the way we collate the data, the way we publish the data. Even though the open source models are generally exempted from the transparency obligations of the AI Act, because generally we should know how the open source models work, they don't always provide all the information on training data. So even they need to provide this summary so that they are not exempted from the obligation to inform the copyright holders. So that, I think, is the way that I would say it's the main way. But obviously, we still don't have a long experience of implementing and enforcing these provisions. Already we know what is sufficiently detailed. There's not a sort of hard line in understanding what that means. But I think we have seen that the companies that are major users of copyrighted material take this very seriously. And we've seen them, for instance, strike these licensing agreements to ensure that they are complying with the copyright provisions. So just as an example, OpenAI has licensed the data of Axel Springer, which is a major publisher that owns Political, that owns Business Insider. They have a licensing agreement with the Financial Times. So I think these companies are now trying to make sure that this is the way that they are really able to use very beneficial, traditionally copyrighted material by having this licensing. Roy, there's obviously, this is a big conversation in the EU as well, how we should think about licensing. There are some who say that, look, is this going to be contrary what the EU wants, meaning a little bit more of a redistribution of the benefits of the digital transformation, not just for the tech giants, but for the smaller players? Is it just the big guys that can afford to pay for these licensing agreements? And does that mean that it only entrenches the power of the OpenAIs of the world that can afford to strike a deal with Axel Springer? But that's just to give you a little bit of a flavor of how we are currently seeing the companies going about they copyright-related obligations under the AI Act.
Yeah, it's interesting. So if you look at the history of CCC, which is voluntary collective licensing globally, we started getting into global licensing decades ago, in the first sort of digital transformation, because our clients might have been headquartered in the United States, but they had operations in other countries and they needed a single license because US law on copyright might have been different and is in fact different from UK, Japan, and while copyright law certainly under the Berne Convention has some commonalities, there's a lot of variation. And sort of like what you were talking about, how sometimes, well, if you're going to comply with EU anyway, it's sometimes easier to have a single compliance regime. That's how we look at it. So before we added AI rights to our licenses, we were waiting to hear from our corporate clients. The publishers, of course, want to license the AI. They want to, make that available under terms that they deem reasonable, of course. But it was actually the drive from the clients who said, give us something where we cannot have to worry so much about whether this is under the non-commercial exception in the EU, which might be subject to a rights reservation and opt-out, or in the UK where there is no non-commercial exception, or the US where we have 60 plus cases debating how far fair use goes in the training. Just give us something simple. And that's how I think that's how the Brussels effect works in a similar way. It's very similar licensing. At some point, people might want it, they might not want it, but what they want is simplicity. At some point, you just like, I can't manage this anymore. Yeah. I always laugh at sufficiently detailed summary. It's one of those lines that we used to joke in law school was the full employment for lawyers language. We can spend the next 20 or 30 years debating that. And I do just want to mention, I think it's out of scope for today, but when you be curious your reaction, not on the details, but on the premise. So we have another AI case that was recently decided, I think today or yesterday in the EU. So we've got a bunch of these cases. We have a case in Denmark discussing what rights reservation needs to look like. And we had one case in Germany where song lyrics, which came out of the AI, the court said, well, because it came out of the AI, it was in the AI. I don't read German. This is my understanding of the case. Because it was in there, then it's not text and data mining. It's not the exception. It's just being stored there. This other case, which I read about, seems to have gone a little bit the other way. How unified is the EU? Just to bring it up, and people should look into these cases if they're interested. Again, out of the scope. How unified is the EU even when it comes to copyright matters? Sure, you've got a directive, but you've got national laws as well. How does that all work?
Yeah, so Roy, there's basically two ways that the EU issues these regulations or directives. And when we talked about the AI Act, that's a regulation. The GDPR is a regulation. The copyright directive is a directive, and directive has the benefit, many would argue, that it allows for more national variation. So if the member states have different views on an issue, they are more likely to agree at the EU level to a directive, whereas they might be hesitant to go all the way to the regulation that harmonizes more. Because the difference is that the regulation is what we call in the US like self-executing. It's directly applicable in the member states. The directive you need to transpose into national legislation. So that means there's more variation. So that variation, while it preserves the member state sovereignty more, it is often more costly for actually trying to do business across the EU because there is more fragmentation. The digital single market is not as complete if we have the different national implementation regimes. And right now, when there is and we may want to talk a little bit more about this entire competitiveness drive in the EU at this moment, there's great concern that the EU is behind when it comes to competitiveness, economic growth, technological development. Where are the EU's tech giants? And I think one big culprit is the fragmentation of the digital single market. And there are many experts who are now really blaming the directives as one reason to sustain this fragmentation and complicate the compliance efforts across the EU. And copyright obviously falls in that category. So these voices are calling that we need to move from directive to regulation, and it happened in the privacy space before the GDPR. We had a data protection directive. It was seen as sustaining too fragmented marketplace, and the member states then upgraded, if you like, that into the GDPR. The question is whether we might see that happen also in the copyright space, because right now there is I think a different momentum to the conversation than in the past. That what do we do to make sure that the European tech companies can benefit from the scale of the EU market, which means it needs to be more integrated, there needs to be less national variation, there needs to be more harmonization. So I would say that this is a very timely conversation, and more we learn about the details of those different cases leading to different interpretation across the EU, the clearer it is for us that there is an impediment to sustaining a truly integrated, efficient, large-scale marketplace.
Yeah, it then does point a little bit back to some of the themes that you've touched on before. For example, if you know implementation's going to vary, you just find the implementation that you think is sort of the most comprehensive and say, I'm going to abide by that. So again, whether it's GDPR, complying with the most stringent, well, GDPR is a different example, but whether it's complying with the most stringent rules or just getting a license that sort of covers everything, sometimes you think, I don't really need this, but I might need this here, here, and here. And I have the what we refer to as the Swiss cheese approach to everything. It is interesting. In the sort of government relations context, I think there's this trope that I sometimes hear that the US is falling, that the EU is falling behind on AI innovation because of copyright law. And I'm sure, there's someone else saying EU is falling behind because of the cost of electricity, but I'm in the copyright debate, so I'm always hearing this one. And it's fascinating to me. First of all, my lived experience is I talk to probably 5 startup tech companies in the EU for every one I talk to in the US. But it is true that the larger, tech companies that have sort of been going out there faster and caught the names do tend to be US companies. I always think it has some more to do with, frankly, financing and access to capital. What do you sort of agree with that there's just like way too much in here to reduce it to one issue?
Absolutely, Roy. I think it's a really important corrective to the current conversation, because there is this very sticky notion that Europeans regulate, Americans innovate, and all these digital regulation, whether it's AI Act or copyright, are holding back the European companies. So you look at that Americans don't have a federal privacy law. Americans have a more generous fair use in copyright. The Europeans have not been as techno-libertarian or techno-optimist, if you like, and that's why there is no European tech giant. I really think that's an unfortunate narrative. And while I'm not here to defend every line of every regulation coming out of Brussels, I think regulation can be a tremendous source of stability for companies to operate. Companies like predictability, they like simplicity, they like to know what the rules are. And also, I think the idea behind the EU's AI Act was that if you have public trust in the safety of AI, that their rights are protected, the risks are mitigated, then the uptake of these technologies is also likely to be greater. There's actually right now in the United States notable public backlash against AI, which may constrain the AI development in this country when the public don't trust necessarily the safety of these models. They don't trust that these models are regulated. And I would say that they are not very comprehensively regulated in the US compared to the EU. But maybe to answer that then, for anybody who wonders if it's not digital regulation, the question remains, where are the European tech giants? And there I completely agree with you. One big issue is finance. There is no deep, robust, integrated capital markets union in the EU. So the European tech companies, they can raise money in the first few funding rounds, but when they need more money, they need to turn to American venture capital, or they are acquired by the US tech giant. So again, it's not the GDPR or the copyright that is holding them back, it's money. The other one we've talked about is the market fragmentation, the use of directives. It is really hard to scale across 27 different markets. The US doesn't have the same kind of heterogeneity and same kind of fragmentation. There was actually a really interesting European Central Bank study recently that was quantifying all these internal trade barriers within the EU and converting those into tariff equivalents. And they found that if you convert them, there's an average 60% tariff for trading goods and about 100% tariff for trading services in the EU. Those are not American-imposed trade barriers that the Europeans often are worried about. Those are European barriers, and they are for European regulators, the lawmakers, to remove. So I think those are examples of, I think, much bigger structural problems for the EU tech ecosystem. I would single out punitive bankruptcy laws that often deterred risk-taking, and a much more successful immigration policy in the US. So the US has been more successful in harnessing the global talent. If you look at who is developing these AI models in the US, the top AI research, there's not just American talent, there's global talent. So I think we need to be very clear when we criticize the burdensome European regulations and somehow draw a causal link to lack of innovation. I think we need to have a much more nuanced understanding of what is driving innovation and what is the relationship between digital rules and innovation.
Yeah, I also think we need a more nuanced understanding of what fair use is in the United States. I follow the cases. We have 3 decisions, preliminary decisions on AI training, 2 generative, 1 stated non-generative, but it's like almost a rag case. And the only thing consistent among the preliminary copyright decisions is their inconsistency. Yeah. One's fair use, but huge liability for an act of getting infringing copies. One was not fair use. It was deemed very competitive. And then one was deemed fair use, but the court really went to lengths to say it shouldn't have been fair use. It was just pleaded incorrectly. So there's not a whole lot of certainty around copyright right now in the US. In fact, fair use is just, everyone who's a copyright lawyer knows, it's all fact dependent. And that's part of it. When we're talking about market conditions, one of the questions, we've gotten a lot of questions about, we're talking about the EU, we're talking about the Brussels effect. Clearly there's a US effect, and I'm going to argue perhaps there's also a China effect. When you look at the the AI race, seems to me there seems to be a lot going on between China and the US. Can you speak to that a little bit?
Yeah, no, I think there is a just tremendous focus right now on this increasingly, I would say, intense AI race between the US and China. That's where the EU is not seen often as a player, except maybe when we talk about the race to regulate, who is shaping the standards. But if you think about just developing AI, one question I always ask, like, what's the goal here? What is even the race we focus on? There are some who say the race is about who reaches the artificial general intelligence first. And there, I would say the US has an edge. The US is doing better when it comes to frontier AI, the most powerful foundation models. But China has an edge when it comes to, I would say, global adoption of the Chinese AI stack. China has focused a lot on open source AI. They are more affordable than American AI models. So they are in high demand, especially in the developing world, where organizations and individuals and governments are striving for having access to digital development, and they want to have technologies that they can afford. So China is doing really well there. So in the model layer, I think the US has the frontier edge, the China has the open source that gives it advantage. The US has an advantage today on chips that are then used to train, where I think that's the biggest constraint when the US has had export controls that China cannot access them. The US today has many more data centers, again, a very important infrastructure layer in AI development. But well, at the time of, for instance, the Middle East, the crisis around and energy prices, the US is facing constraints on energy. China has a much more diversified energy infrastructure, is adding much more power to its grid. So China will probably prevail in being able to power those data centers. There's also a lot of public backlash on permits for data centers and so forth. So I think we need to think about the entire AI stack and sort of where the various what the race looks like in each layer. The one that I would want to finish with is that the application layer, because ultimately we want to make AI useful. We want to make sure that AI serves societies, it serves individuals, it serves organizations, that we can actually get those productivity gains. And that means we are putting AI into good use. And again, when the US companies have been, many of them, so focused on kind of pursuing the frontier AI, China has been very busy making AI useful in terms of applications. And I think that's something that we also must focus on, that all this tremendous innovation and capabilities in this country, that we also reserve a lot of that attention and innovation capacity towards making sure AI helps our healthcare sector, our education sector, our agriculture, our manufacturing, and that we really focus on kind of adoption of AI across the different verticals of the society.
Yeah, that's in fact one of the places where I tend to be, although I'm obviously strongly believe in copyright and licensing, very optimistic about AI. And what I've seen is the more recent trend, once we get past however training was done, and you can look at the cases and see, where things were taken, and there wasn't a lot of licensing going on, and the original model building that I can tell. We work with corporations, we work with pharma, and pharma wants to use AI, and they need to be able to trust what they're using. So to me, the notion of disclosure of training data, and then disclosing what's in there, which I think the EU put in, not really for copyright purposes, but for safety purposes. Yeah. There was some copyright benefit or drawback, depending on your perspective on copyright. These are the things that I think will actually empower AI, because if you're using it for what I sometimes refer to as high stakes applications, and high stakes doesn't really, all that means is you're not using the AI for entertainment. You're using the AI because you have a business purpose, whether it is grading a paper, whether it is inventing a new drug, whether it's educating, whatever that purpose is. As long as you have a purpose, you need to know how the AI was trained, so that that's blunt, that it wasn't just trained on a bunch of AI slop. So you want to know it was trained
Yeah.
on good stuff. You want to know what that good stuff is, because our clients come to us and they are really particular as to what they will use.
Yeah.
They're not saying, give me everything from a respectable oncology journal. They're like, give me what you can get from these 3 titles, because these are the only ones I really feel like I want to rely on. And I think it's clear to me that in the last few years, a lot of the tech innovation, both from the big firms and the startups, is along these lines. It's about, okay, what are we using? What is the
Yeah.
stuff? How can we tell them what they're using? That's beneficial to copyright, sure. It's also beneficial for safety, is beneficial for business and outcomes. But it's one of the things that I was hoping and sort of suspecting would happen. I've been seeing this accelerating. I don't know if you have any thoughts on this, but I do think it's one of these ways in which, the Brussels effect plus the requirements in Illinois and California law and everything else are all sort of leading to this place where, as you say, the applications can be applications that are not, so many people that, oh, it's AI, I don't want to go near it. We need to get to the point where it's AI, I trust it, right?
Exactly. No, absolutely. And I think it can be a very important way for companies to distinguish themselves in the more competitive landscape is what is the quality of the AI model? And I think the key question I would ask, how was the model trained? And that means there needs to be very extensive, very clear, very digestible way to disclose how the model was trained, because it is very hard to sort of not to recognize that the direct relationship between the quality of the model and its ability to then perform inference is also a function of how the model was trained. And I think generally one of the kind of founding principles in how the EU thinks about regulation in this space, one is that it needs to be human-centric. One is that we need to make technology serves humanity and not extracts and exploits as humans. But I think also the idea of like transparency is extremely important. It's how the EU regulates content moderation, the Digital Services Act. There's a lot of applications that we need to open that black box. We need to know how these companies are moderating content. Nobody in Brussels is going to review every YouTube video before it is posted, but we need to make sure that we know how the YouTube goes about the content that is allowed to stay up there, how it makes sure that the copyright is respected of the kinds of music that is uploaded on YouTube and so forth. So it is really comes to this central question of trust. And trust is really tied to the disclosure and transparency so that we understand how these companies operate, how their business models operate, how their products and services are built.
So do we think that, I mean, certainly a lot of the startups I'm working with who are, focusing on a market, they're all about trust. But do we think that that's so let me back this up. I've seen, for example, in proposed legislation in Congress, there's been a shift, I think, among not all, but some of the tech companies towards, I don't want to say that they're in favor of disclosure of training data per se, but there's been a little bit of a shift. I don't know if you're as deep in this as I am, on this sort of, well, licensing might be okay in certain circumstances. And, you already, mentioned some of the licenses, OpenAI and Axel Springer, that as these markets get developed and go from, hey, we just want to rush out this AGI thing and get people using it, to we need to get people paying for it and buying it. Do you think there's going to be a little bit of a convergence here? I'm hoping so, between, kind of tech and content, where we see more and more collaboration on better outcomes?
So I think in some sense, yes. And it goes to this idea that I think that tech companies know that there's a trust deficit at this point. They don't always get the benefit of doubt. There's a lot of, I think, public asking the questions how these tech companies are acting that are in public interest and not just to pursue their profits at the expense of the kinds of nuanced regulatory compliance that we expect to preserve our rights and to mitigate against these risks. So I think the tech companies understand, and that's why I think they often then come around to embracing some regulations. And I think that's why some of these tech companies decided proactively to sign a voluntary code of conduct of the AI Act, including the chapters on copyright, because they need to demonstrate their good faith attempts to comply with regulations. So obviously, we don't yet have the level of compliance. Otherwise, we wouldn't have these cases against the tech companies if the compliance was at the level that we thought it was adequate. But I think there is certainly a connection between the public trust, which is in short supply, and the attempt to breach that gap and try to build that trust towards then concrete manifestation that regulation is not an enemy. Ultimately, these companies can only thrive if businesses and consumers are willing to use their products. And ultimately, we certainly don't want to be in the situation whereby regulation only comes when something really bad happens and we realize that we had not been responsible about governance. And I think that's why we want to make sure that it is preemptive and proactive.
Yeah, and I'll say this even about the AI Act. I mean, I feel like often regulation solves yesterday's problems tomorrow. So it's very hard to keep up with what's going on simply because, and again, I said this at the beginning with AI, especially the market has changed so much in the last 2 years. I struggle dealing with it day to day on a business development basis to keep up with it because it just changes so quickly, and it is very hard for regulators. But I think everyone wants to focus on trust. Everyone wants to focus on good outcomes. We can get there ahead of regulation. Maybe the regulation will come, maybe it won't. I did want to come back to one concept, something you'd mentioned earlier, and you and I have talked about this, and it's such a bit of a pet peeve of mine, basically from where I'm sitting. There's now this sort of argument I'm hearing that, well, licensing only befits the large tech companies because they can afford to pay for licenses, and therefore the smaller tech companies are shut out. And I obviously feel really strongly about this, particularly, the collective licenses we offer, but also having worked at publishers and with publishers, licenses scale. The largest company in the world doesn't pay the same amount for a collective license, from CCC as a startup. If you have 5 employees, you pay way less than if you have 500,000, and yet you still have access to the same rights. So I do just wanted to get out there because that's a pretty frustrating concept for me that somehow the small and medium enterprises get shut out, where in fact they get a lot of advantage because they pay very little for quite a lot. And I just go to I've been working some of the questions in, but there's a long question here. I just want to read from an anonymous user talking about legislatures have taken inspiration from the AI Act. There's also been a lot of pushback, particularly the UK. So the UK, as I mentioned before, has had a non-commercial TDM exemption for a really long time, and has rejected a commercial one. Then in the last 5 years, I've been deeply involved in this, has gone back and forth as to whether they should, and the creative community there really pushed back. Australia basically said, yeah, we're not going to do a TDM exception. US is a little bit slower. I know the US well enough to know US is just pretty slow to regulate. We're kind of struggling these days in Congress. So the question here is, what if, how will the EU, how will the Brussels effect work if it turns out that the UK and Australia and all these other countries actually have much stricter copyright standards? Does that negate the Brussels effect, or is the Brussels effect just not really a Brussels effect, but just a broader effect of how markets function?
Yeah, so generally the Brussels effect it follows the idea that the most stringent regulator prevails, assuming that most stringent regulator is sort of big enough of a market. that the companies just can't afford to ignore that market. And this was a little bit of a test case when the Australians were pushing for the bargaining codes already when it comes to paying the newspapers, for instance, for these search engines and the platforms to use the link their content. And there was a kind of a hardball tactic by some of these companies saying, okay, we're not going to offer our news in Australia. So sometimes if a smaller market, and granted the UK and Australia are smaller than a 450 million market of the EU, they may not have as much bargaining power. This same happened when it comes to the online copyright space and news bargaining when Spain tried to go alone and tried to basically force the compensation for the news outlets. And the companies basically say, well, we go dark in Spain. But when this was incorporated in the EU's copyright directive, it is a harder thing to ask. And these companies said, okay, we are negotiating. So I think we may have elements whereby some players decide we use the EU baseline, but we add something for the UK market. We add something for the Australia market. And sometimes we see, for instance, right now, Australia, by being very strict in banning social media for minors, that is also spreading in other parts of the world. And when it spreads to the EU, like many parts of the EU is now considering that, and the EU is moving towards more stringent rules, that really gives them the leverage when it can be a Canberra effect converted into the Brussels effect, and that then pushes towards greater global compliance. So it doesn't necessarily negate the Brussels effect. It can add something to the Brussels effect, but I think the smaller the market, the more you run the risk that the companies choose to exit or impose real costs. They often threaten not to offer products and services in the EU. That has happened. For instance, Apple says, well, we're not going to introduce the AI features in the EU. Often they are introduced with delay. Or then they are some kind of additional features that it's not kind of enough for the EU users to say, look, we need to give in to their demands. We can't live without these features. It is really tied to the purchasing power, the consumer power that any given market has.
Great. We only have a couple minutes left, and so I just wanted to, again, thank you so much for doing this. Remind people that this is part of an ongoing program that CCC is running. As I've said, I know what the next one is. You don't, but it's going to be a good one. We have amazing resources at copyright.com, all about AI. We have a lot of educational programming and things like that. Here's some of the information. I don't want to put you on the spot, Anu, if you have any final comments or not. I just wanted to, again, wrap this up, and I think this has been wonderful. So thank you. And if you have any closing remarks or not, it's up to you.
No, this was really great. Thank you so much for having me. Thank you, everybody who joined today. This is obviously a fast-moving space, and a lot will happen. There are pressures to find the right way to regulate when the countries, including the whole jurisdiction of the EU, is trying to make sure they will harness the benefits of AI, but at the same time mitigate against the harms and the downsides. And the AI Act is a really important development in trying to get this regulatory goal right. So I'm glad that you signed on to today's talk to feel that you have an ownership of this conversation and follow how the implementation will now unfold and how far-reaching the effects will be. So thank you so much, Roy, for having me.
Thank you. It's been wonderful. Right, everyone, enjoy the rest of your days, your mornings, your afternoons, your evenings, depending on when you're calling in from.